Madam Deputy Registrar, good morning. Would you mind commencing proceedings, please?
Good morning, President. Caribbean Court of Justice, appellate jurisdiction on appeal from the Eastern Caribbean Supreme Court, Saint Lucia, hearing of CCJ appeal LCCV number 2 of 2025 between Mr Chastanet and the Comptroller of Customs and Paul Noel. The members of this morning's panel are Mr. Justice Anderson, President, and the presiding judge.
Good morning, Counsel.
Madam Justice Rochnors Lee.
Good morning to everyone.
Mr. Justice Barrow.
Good morning.
Madam Justice Ononiwu.
Good morning, everyone.
And Mr. Justice Ebo Osuji.
Good morning, all.
May we have the appearances, please? Thank you.
Good morning, Your Honors. My name is Garth Patterson, and I appear in this matter on behalf of the appellant, Mr Chastanet. And with me are Mr. Mark Maraj, Ms. Akelia Richards, and Ms. Tanya Alexis Francis.
Okay, thank you, Mr. Patterson.
If it pleases the court, the usual snack, appear on behalf of the respondents in this matter. I'm led by my learned senior, Mr. Anthony Astefan, who will be making the presentation on behalf of the respondents this morning. Mr. Schumann Emmanuel, Comptroller of Customs, is present on the platform.
Thank you, Mr. Sunak.
Thank you.
Okay, so I think you had received the CMC order, which indicated the time frame that you are allotted to make oral submissions. Of course, that is flexible. We'll see how we go. And we are now prepared to hear you, Mr. Patterson, for the appellant.
Thank you, Your Honor. I was actually looking for that CMC order last night and couldn't find it. So if the court would do me the gracious honor of reminding me of what my limitations are.
1 hour, as I recall it. But of course, as I said, 1 hour, but that is flexible. We'll see how we go.
Oh, okay. Much obliged, Your Honor. Well, let me just get straight into it. I will take it, Your Honor, that the submissions are before the court. We will rely heavily on the written submissions, both those that were submitted in support of this appeal and also the submissions contained in the record. An hour is a very short period of time to cover a lot of ground. And so maybe what I might usefully do is sort of precede the case of the appellant. It seems to me that the case must be heard within the context of the background. This is an appeal which challenges the dismissal of the Court of Appeal of the appellant's appeal against the High Court's refusal to grant leave for judicial review of the respondent's decision to discontinue criminal proceedings against Dr. Ernest Hilaire, who is then a cabinet minister. The appellants say that the evidence adduced by him established the following chronology of events. Over a period of 3 years, from November 2017 to July 2020, extensive investigations were carried out by the Customs Department in consultation with the Attorney General's office and the DPP's office into alleged contraventions of the Customs Control and Management Act. I just referred to it as the Customs Act by Dr. Hilaire. As a culmination of those investigations, 3 informations were laid by the Comptroller, Peter Chico, against Dr. Hilaire under Section 102(3) of the Customs Act in October 2020. Mr. Chico sent all the files to the DPP in January of 2021 for onward prosecution with a covering letter to that effect. Between January and December 2021, the DPP's office paid 7 appearances in the matter before the magistrate, which was adjourned 7 times, and at mediation on June 28th, 2021. On June 20,
I gather, Mr. Patterson, that there was no official or formal response to that letter to which you made reference.
No formal response that we are aware of.
Yes, okay.
But we say that the response was that the Attorney General, the DPP's office subsequently attended to the matter on 7 occasions and at mediation. On June 28th, 2021, Leslie Mondesi appeared on behalf of Dr. Hilaire in court-ordered mediation of the criminal matter. General elections were held and the government changed in July 2021, and Leslie Mondesi was appointed as Attorney General. Sherman Emanuel was Mr. Chico's subordinate, was appointed as acting controller on October 1st, 2021, replacing Mr. Chico. 6 days later, on October 7, 2021, Mr. Emanuel met with now Attorney General Mondesi to discuss Dr. Hilaire's case. On December 1st,
But Mr. Patterson,
yes,
that is contested, isn't it?
much of what we're saying is contested.
Fair enough.
On December 1st, but this is the evidence of Peter Chico, who was the then Comptroller of Customs and who gave evidence based on first-hand knowledge. On December 1st, 2021, Sherman Emanuel again met with Attorney General Mondesi to discuss the case. Following day, on December 2, 2021, the 3 informations were withdrawn by Sherman Emanuel exactly 2 months after his appointment without consulting the DPP, and his reasons, according to him, that he did so for no other reason than that I formed the view that there was no basis for the prosecution to continue.
Mr.
Appellant.
Chastanet, you say that there was no consultation of the DPP. How does that picture in this matter?
So the record will reflect, Mr. Chico's affidavit will reflect that the matter was investigated over a 3-year period in consultation with the DPP's office and the Attorney General's office, who advised on the prosecution for 3 years. The information were filed in conjunction with the DPP's office, who then took over the prosecution in January of 2021. When Sherman Emanuel was appointed as acting controller in October of 2021, within 2 months without consulting the DPP, who was actively involved in the matter, he simply made a unilateral decision to discontinue the case. We say, after consulting with Attorney General Mondesi, who was Dr. Hilaire's personal lawyer and acted for him in the criminal proceedings.
Mr. Patterson, let me come in here. I've read your submissions, and I take it one legal argument you make, which personally I do find has a lot of force to it, is that the DPP's powers to withdraw or discontinue criminal prosecution. We can call that the nolle prosequi power of the DPP, cannot be equated to that of the comptroller. That's your argument. You're arguing that this case should not be analyzed on the basis that the comptroller has a power similar to the DPP's to withdraw the case. Is that correct?
Yeah, there are a couple of nuances to that. So we're saying the comptroller had no power to withdraw the case, that the DPP is the constitutionally appointed prosecutor for the state, and decisions to discontinue prosecutions, whether started by the DPP or by some other prosecuting authority, are within the exclusive preserve of the DPP unless that power is expressly conferred. And we say there's a reason for that. And
no, hold on. Hold on. I
Yes.
just want to get at something here.
Yes.
All right, so far so good. But
Yeah.
if we looked at section 73 sub 4, not the main part, but the proviso part,
Yes.
that proviso part does make an allowance, doesn't it? That allowance is that any other authority other than the DPP, the provision allows for discontinuance of prosecution if the judicial leave is granted to do that. Is that correct?
Our position is that that provision simply preserves that power if that power has been conferred. It is not I think that proviso does not confer the power to withdraw.
Yeah, so far so good. I know
It
that,
says
that's what I'm
if
saying.
that power exists, then the provisions of section 73 will not preclude the exercise of that power by that functionary. So we are saying that the comptroller never had that power. It's not
Now,
expressly conferred.
in the context of a criminal case,
Yes.
let's assume that there is no explicit statutory provision somewhere that says anybody other than the DPP who commences a prosecution can withdraw it. Let's assume we find no explicit statutory authority for that.
Yes.
But some other authority other than the DPP who's authorized to commence prosecution commences that prosecution, but at some point finds that, look, continuation for whatever reason, whether or not we agree with it, forms the view that this case should not continue. Maybe if it continues, it will be unduly oppressive to the defendant, or for whatever reason, a waste of resources and all that. But the person decides, I want to discontinue this case. Are you saying the person cannot discontinue it with leave of court?
I'm saying that the person would refer that to the DPP, who could then make that decision. And let me be clear. It is our position that the reason the Constitution vests the DPP with that almost exclusive power to discontinue proceedings is exemplified by this very case, where a lawful prosecution is commenced, and for political reasons, it is discontinued by the prosecuting authority. The DPP, having the character of independence.
Yes, I know. I'm not done with this inquiry, Mr. Patterson. Now, I'm looking here at page 626 of the appeals record. I'm sure you know where I'm going with this. Page 626, 628, and 630.
Yes.
See that? All right, these are the same documents. I think perhaps 6.
These are the information.
It says Form 200B of the Criminal Code. You see that?
Yes.
All right. If you looked at perhaps 6 to 8 might be clearer in what I'm trying to do here, because 6 to 8 has a stamp that's easier to see. It says First District Court, Clerk of the said District Court. You see that?
I see that, yeah.
And if you look at the beginning of the document, it says here, it was a, but by the way, the title says here, in the First District Court. Noel, Paul Noel, Customs Inspector to Customs and Excise Department, complainant versus Dr. Hilaire. And it tells us it was adjudged and ordered by the said court, sitting Castries D Court. Said adjudication was, on the 22nd day of December 2021, matter against the defendant was withdrawn after mediation. The said adjudication was consequent on withdrawal, and so on and so forth. And then at the end, we see the stamp and signature of the stamp of the district court and signature of the clerk of court. That is telling us something. It's telling us that the district court or the magistrate made a decision to withdraw this case. Isn't that the case?
I don't know that magistrate can withdraw.
No, but I'm saying, forget about that. Whether or not it's correct or not, something else. But looking at this document, it is telling us that there was a judicial act, and that was withdrawn to withdraw the case. Isn't that the case?
But with respect, our interpretation of that is somewhat different. We see it as a notation. It is simply noting the fact of withdrawal. It's not an adjudication.
Mr. Patterson,
in other words,
excuse me, in relation to my brother's question,
yes,
I think my brother could also have added that in that order, there was an order for the return of the vehicle.
No? I think that was in a subsequent order. I don't see that recorded in this document. But there was an order for the return of the vehicle. But that was...
I am looking at 626.
626.
Yeah.
So,
the matter again was withdrawn.
Yes.
And then the Comptroller of Customs is to release one used Land Rover Discovery by 3/12/21 and delivered on or before December 10th, 2021. So there is an order to deliver the vehicle back to the defendant. Is that not an adjudication and a determination that this matter is concluded, counsel? Help me.
Yeah, so as I understand it, when a matter comes before a magistrate on information, yes, one or two things will happen. He will either try the matter and either dismiss it or convict, or the matter, if it is withdrawn, is simply noted as withdrawn. It has not been tried. And so there's no adjudication or consequence on a withdrawal. It's simply not tried. And there's authority for that. That explains that.
Mr. Patterson, I hear what you're saying.
Yeah.
But this document says it is ordered and adjudged. So we just disregard that?
Well, that seems to me to be a printed form that they fill in.
Yeah, it is a printed form, yes.
That they fill in detail.
They tend to be.
So the point I'm making is that what it is, in effect, is a notation of the fact that the comptroller had withdrawn the matter. It's not
All
an
right.
adjudication. Where the matter is withdrawn from the court, there is no adjudication.
But
All right, let me point
Mr.
to-
Patterson, but the
Yes.
order saying return this vehicle, that also is simply an adjudication?
No, that's an order.
Well, then, the whole thing is an order, isn't it?
But we are not contesting that part of the order.
But
We're not
Mr.
even
Patterson, it
contesting
does not
the
matter
order.
what part you are contesting. What matters is the nature of the document. Listen, the matter is taken further by the affidavit of Mr. Shiko, who says in relation to this, that Mr. Lon Theophilus, on that hearing, when the withdrawal took place, asked that the matter be dismissed, and the magistrate agreed that it should be dismissed. So it seems to me, Councillor, and I'm simply trying to get your view to rescue me from being led down the wrong path. It seems to me that what there was a determination that this case is ended and that orders made in the course of the case are now, as it were, removed or set aside. This man is to have back his vehicle, etc. So how is this not an order? How is this not an adjudication? Help me there, Counsel, please.
So when you look at Peter Chico's affidavit, he does confirm that in the court, there was a request for the matter to be dismissed. That was not ultimately reflected in this order. That's what he says. And what we have reflected is a notation by the court that the matter was withdrawn, not dismissed. And in my submission, it would not have been possible for the magistrate to simply dismiss the matter. You can dismiss it after trial, but not simply.
If I may, as a matter of record,
Yeah.
I'm looking at paragraph 31 of Shiko's affidavit,
Yes.
and he says the magistrate agreed to dismissal. He says, if you go over the page 741, same paragraph 31, the first sentence on that page, the magistrate then announced the dismissal and closed the case. Mr.
Yes.
Shiko says this. So
That's what he
again,
said,
I
yes.
need your assistance as to why I should not take this as what Mr. Shiko says it was.
But what Mr. Chico says cannot override the formal order of the court, which is reflected at Exhibit AC12.
I will take that as
But-
your response.
Mhm.
Thank you, Counsel.
But in
Councillor
either
Wong-
event, Mr.
Sorry.
Patterson, don't we have to treat with the questions raised by our brother earlier, whether it's a dismissal or a withdrawal? This is a decision taken by the magistrate. And I think that perhaps Justice Osuji was getting at that point, whether you ought not then to treat with that decision by the magistrate rather than a decision by the Comptroller of Customs.
Well, the magistrate, as we see the order, I mean, we can only go by the formal record. The formal record of the court says the matter was withdrawn, and it was withdrawn by the Comptroller of Customs. And the judicial review application is challenging the decision of the Comptroller to withdraw it. Bear in mind, this order did not happen on its own. It happened in the context of the Sherman Emanuel. And if you look at his affidavit, he said he made the decision to withdraw the case.
So where does it say that it was withdrawn by the magistrate? I'm not sure I see that.
No, it's not withdrawn by the magistrate. It was Sherman Emanuel, the then acting comptroller, who said he withdrew it.
Mr. Patterson, one question I have, the legal question at the end of my question is this. If this court forms the view that the magistrate did grant leave to withdraw the prosecution pursuant to Section 73(4) proviso of the Constitution. Let's assume that that's the finding. Would you accept that there is no case to make about judicial review of the controller's request to withdraw or action to withdraw? Rather, the proper course would be to attack that judicial decision either by way of a judicial review of the magistrate's grant of leave or by an application to set it aside.
Well, the question is whether, from our, if we go with your hypothesis that the magistrate, in fact, was asked to grant leave for the withdrawal of the proceedings. You look at if you look at the proviso to Section 73(4), it says nothing will prevent the withdrawal of those proceedings.
Yes.
By or at the instance of that person or authority. So there are two limbs to it. The withdrawal by that person, yes, and the granting of leave. There are two limbs.
And yeah,
we're saying if the first limb was unlawful, if there was a breach of the Constitution in that, there must, as a predicate to the exercise of a power to withdraw, there must be that power to withdraw. So that if you purport to exercise a power that you don't have, and it's sanctioned by the magistrate, there are two wrongs. It is a wrongful exercise of that power that you don't have, and then the granting of leave by the magistrate in relation to a wrongful exercise. If the magistrate hasn't got the facts before him, and there's nothing on the record that suggests that an application for leave was made, or that the magistrate indeed even addressed his mind to provisions of Section 73(4), there's nothing on the record to suggest that. There's no affidavit by Sherman Emanuel or anybody else saying that an application for leave was made. The magistrate considered the matter, because we say that Section 73(4) requires a positive act. It's not just there for the sake of show. It requires the magistrate to actually deliberate on the question whether or not leave ought to be granted. And the reason why it says so is that it is a safeguard.
Is that beyond an attack? The fact that the magistrate made a decision without reason, isn't that enough of a basis to seek to set it aside or to seek judicial review of it?
Well, we said there are two actors, and we could proceed.
Can one do it without the other? Can we have the first part of that without the second?
Absolutely. In my submission, the first part of it relates to the exercise of a power by the Comptroller of Customs. And that power is subject to the Constitution. The Customs Act says that the powers of the Comptroller are subject to the powers of the DPP. That's what it says. And so we are attacking the purported exercise of a power by the Comptroller, where our focus is on the Comptroller, not on the magistrate. If the magistrate has not been filled in with all the necessary facts, has not been advised of the provisions of Section 73, which required him to deliberate on the question whether or not leave ought to be granted, if his mind was not adverted to those provisions, if he was not aware of all the facts.
But Mr. Patterson,
then he can't be
criticized.
premising
The accuracy of what you're saying. The magistrate is totally kept in the dark as to his lack of competence, lack of jurisdiction on the part of the controller, etc. The magistrate nonetheless makes an order or a determination that this matter stands dismissed. Is it not still dismissed?
Well, that's not what he said. The magistrate's order is that the matter is the magistrate simply noted that the order was withdrawn.
All right, sorry, hold on. So, forgive me, allow me to correct myself. The magistrate notes that the matter stands withdrawn.
Yes.
Is it not still withdrawn by order and the imprimatur of the magistrate?
It is withdrawn by the Comptroller of Customs. It is only the Comptroller who can withdraw it.
With respect, Mr. Patterson, the magistrate went on in relation to that withdrawal to make a consequential order.
He did.
Therefore, the withdrawal has to have been accepted by the magistrate as being the legal state of play at the time, necessarily.
There is no question that the magistrate acted on the fact that the matter was withdrawn. Whether he addressed his mind to the legality of it is unclear. There's nothing on the record to show that.
And equally, there's nothing on the record to suggest that he did not address his mind to it. So why would you assume?
Well, because where the Constitution says, Mr. President, where the Constitution says that the power to withdraw must be exercised with the leave of the court, it implies that an application for leave must be made. The matter has to be considered, and an order granting leave one would ordinarily expect to see an order granting leave recorded in the record. An order granting leave to withdraw. There's no such order. The order simply notes the fact that the matter was withdrawn. Yes. In other words, we're saying the Constitution must be read purposefully or purposely. It has to have a meaning. When it says the leave of the court is required, it contemplates a sequence of events, an application, a deliberation, and an order granting it or refusing it.
And you're saying
so
that
none of that is recorded on the record.
That leave cannot be implied by virtue of the conduct of the proceedings.
No, I don't think it can be implied, because if it matter was never, if it was never drawn to the magistrate's attention, that Section 73(4) specifically requires the magistrate to address his mind to the question whether or not leave ought to be granted, then you can't assume. I think the better assumption is that because the record does not reflect the express grant of leave, that the magistrate simply never addressed his mind to it. That's the better assumption.
But whatever the case is, Mr. Patterson, the magistrate made an order recording that the matter stood withdrawn. Should we simply disregard that?
I don't think that the magistrate made an order. He simply recorded the fact that it was withdrawn.
Okay, he recorded the fact that it stood withdrawn.
Yes.
Yeah, and ordered the return of the vehicle. Should we simply disregard the magistrate's recording that the matter stood withdrawn?
No, absolutely not. Because what we're saying is that the provisions of the Constitution were not complied with. They were
fine, but the magistrate acted.
Yeah.
The magistrate acted in breach of the provisions of the Constitution on your theory.
No, I don't
let's
think
say.
So. Our theory is not that the magistrate acted in breach. It is the controller. The requirement for leave is imposed on the controller.
With respect, Mr. Patterson, after the controller sought to withdraw, the magistrate acted upon that application or that statement that the matter stands withdrawn. The magistrate acted on it. The magistrate recorded it, as you say. Therefore, can we treat it as not having happened?
No, there's no question that the magistrate accepted what was represented to him, that the matter was being withdrawn. There's no question about that. The question that we raise is whether or not that withdrawal by the controller comported with the Constitution. Whether, first of all, whether the comptroller had the power to withdraw in the first place, and secondly, whether that withdrawal comported with the Constitution. And one of the reasons we say he didn't have the power, even if you go along with what the Court of Appeal said, which is that the power ought to be implied, the Court of Appeal itself recognized that once the DPP had taken over proceedings, that power was no longer exercisable by the comptroller. No,
an interesting point. Help me here, counsel. The magistrate also missed the proposition that the DPP had taken over and that the comptroller had no competence to withdraw. The magistrate missed that as well.
I don't know that the magistrate addressed his mind to it at all.
So if he didn't address his mind to it, he missed it.
But we're not focusing, our judicial review application doesn't focus on the actions of the magistrate. We are the decision
should it not be the case that it should focus on the actions of the magistrate rather than that of the controller? If we have a document here, in addition to the evidence your witnesses have adduced in their affidavit, and we are looking at a document here at Appeal Records 626, 628, and 630 that begin with, it was adjudged and ordered by the said court sitting. And then underneath that, he tells us on the second day of December 2021, the matter against the defendant was withdrawn after mediation, and the said adjudication, not the said notation, the said adjudication was consequent on withdrawal. Are we supposed to ignore that and say, well, the magistrate didn't advert his or her mind to it, so let's focus all attention on the controller's motivation of whatever happened?
So, Your Honor, the cases I've seen on this subject, and admittedly, I didn't anticipate this argument, so I haven't produced them, and I certainly can. But the cases that I've read on the subject of discontinuation versus discharge, very quite clear that where a decision to discontinue or withdraw a case before the magistrate is made, where a decision to withdraw it is made, there is no adjudication by the magistrate. The matter is withdrawn, it's taken out of the hands of the magistrate, and there's nothing for the magistrate to decide. So there's no adjudication.
Isn't that a distinction, Mr. Patterson? I hear you, I see where you're going. Isn't that distinction between the powers of the nolle prosequi powers of the DPP versus the powers to withdraw, or rather allowance to withdraw that any other authority may have in relation to the DPP? The cases you are referring to almost would say, I imagine, that the DPP issues a notice of discontinuance, and that notice of discontinuance shall be acted upon by the court. So the court has no choice. DPP issues nolle prosequi notice, and the court shall act upon it. There is no requirement, or rather expectation, of the DPP to discontinue with leave of court. That's one significant difference between the DPP doing it and somebody else doing it.
That's correct.
All right. So here, DPP can do it on their own. So the cases you're talking about may not really help us, because it is where the DPP's administrative act is directly on the line versus another scenario where no other authority can do it quite like the DPP. If you must do it, you must get leave of court to do it. And if court grants leave, that becomes a judicial act, a decision of the court, which an aggrieved person can attack for any number of reasons, including want of reasoning, erroneous ground to make the decision and so on and so forth. But you have to attack the judicial act and not the act that motivated it, that marches into the thing.
The way I understand the case is that whether it is the DPP discontinuing or some other prosecuting authority discontinuing or withdrawing with the leave of the court, the result is the same. The matter is removed from the decision-making capacity of the court. There's nothing for the court to decide on. It's withdrawn. So there is no decision that is made by the magistrate.
The magistrate can refuse leave, though. The magistrate can refuse leave.
Can grant or refuse leave. That's exactly the only decision that he is required to make. But as it relates to the actual case itself, it is not the act of the magistrate that brings it to an end. It is the act of the prosecutor that brings it to the end. So that the distinction I'm making is between an act of the comptroller in withdrawing the case and the act of the magistrate in dismissing the case. And the two things are entirely different and they have different legal consequences. And that's what all the cases show. And the reason why the requirement for leave is there is that it provides us an important safeguard against the arbitrary discontinuation of cases. And as the cases all say, the accused has rights. A prosecutor cannot simply decide I'm going to withdraw the case because it leaves that accused person in an awkward position because the prosecution could always be reinstated, which is a different position than where the matter is dismissed by the magistrate. It cannot be brought again for double jeopardy. And so the courts have recognized that it is important for the court to deliberate on the question whether or not the intention to withdraw should be allowed. It is for the court to decide whether or not the purported withdrawal, whether to grant leave or refuse leave for the purported withdrawal. And it affects the rights of the accused, it affects the rights of the complainant.
So it's not a pro forma, sorry to interrupt, but it's therefore not just a pro forma function. You're saying that the judicial officer has to exercise a substantive judgment to prevent arbitrariness, for example, in deciding whether to grant leave or not.
That's correct.
Right, so it's a very substantive decision.
Process, yes. Constitutionally mandated process.
Yeah, so once that decision has been taken by the court, magistrate in this case, would you not say that that in fact is a legally important supervening event which cuts across the call by the Comptroller of Customs and in fact that is the decision, that substantive decision to grant leave or not grant leave, which then ought to be the subject of scrutiny?
So let me put it this way. Both things can be true. The purported exercise of any presumed authority to withdraw a case by the comptroller can be unlawful. And if it is unlawful from inception, it vitiates everything that follows. Also, the exercise by the magistrate of the power to grant or refuse leave can also be unlawful or can also be subject to appeal or review. Both things can be true. We're saying in this case, we don't get to the magistrate because at inception, one, the comptroller had no power to withdraw. If he had no power to withdraw, the magistrate cannot, by granting leave, validate something that is unlawful to start with.
Even if the magistrate in fact did so.
He cannot do so. It is a
But he
nullity.
did so, but he had an
No, he
order
can't.
issuing saying this matter stood withdrawn.
He
And
did
is it
not.
therefore not, isn't it much
well,
easier then to attack the decision by the magistrate by saying, look, you acted without, considering the constitutional provision 73.4. You acted in a situation where the controller did not have the competence to withdraw. Are those grounds not available to you in attacking the decision of the magistrate?
I'm suggesting, Millard, that where the comptroller purports to exercise powers relating to his undoubted power to prosecute, the statute says so, it's a statutorily conferred power to prosecute, where he purports to exercise powers to discontinue or withdraw that prosecution, he must do so lawfully. And we are attacking the lawfulness of his actions, which if we are correct that he had no power to withdraw for whatever reason, whether he was not statutorily conferred that power, whether the DPP took over prosecution and therefore prevented him from exercising that power, whatever the reason is why he had no power, he had no power. And the magistrate's subsequent recording, whatever the magistrate did will not imbue him with power that he did not have. And so the process of withdrawal vitiates anything that follows. If he did not have the power to withdraw, nothing the magistrate did subsequently can change that. That's our position. And so we say, let's attack it from the source, from the purported exercise of a power that the comptroller didn't have. And when you look at the Court of Appeals decision, they accept that if the DPP had taken over the case over, the comptroller simply had no power to withdraw. The Court of Appeal recognizes that, and the first instance judge said that as well.
Mr. Patterson, see, this case, if it makes it into anything, it may well be into words and phrases legally defined. It will be the meaning of leave, the concept of leave. What does it signify? The grant of leave, judicial leave. Now, here we are.
Sorry. Are you referring to leave for
leave,
judicial
exactly.
review or
Yes.
leave to withdraw?
Leave to do something, judicial leave, grant of leave, grant of leave to withdraw. Here we are, and this litigation is about what? Grant of leave to start a judicial review.
Yes.
If the first instance court had simply said, leave granted without reason, would it be right to attack the party that motivated it? Or would it be the appropriate thing to attack the decision granting leave for judicial review?
I don't think that
is that one way to look at it?
No, with respect, the two things are not comparable. In this case, the applicant for judicial review was a private citizen. He's not susceptible to judicial review.
You can have judicial review by a government department too,
No, but he's not susceptible to judicial review. You can't attack his decision.
I hear you, but I'm saying you can also have judicial review by a government department.
Of a government department or by a government?
A judicial review of grant of leave.
Right. So my view is that the power of the comptroller is derived from the statute and is subject to the Constitution. He exercised or purported to exercise certain powers. And we're saying this court, or the court at first instance, had the power to review the actions of the comptroller. Whether the court also could review the actions of the the magistrate is a separate issue. What's before the court, what was before the court is an application for leave to file judicial review in relation to the actions of the comptroller. That was what was before the court. We're appealing that decision. We're not appealing a decision of the magistrate. We never challenged the decision of the magistrate, if he made a decision at all. Our view is that he made no decision. He simply noted the fact that the matter was withdrawn.
And Mr. Patterson,
decision.
Mr. Patterson, if I may, and what you're asking for is for the prosecution by the comptroller to be reinstated. Is that correct?
Ultimately, yes.
But how can you have the reinstatement of a prosecution by the comptroller when you say it was taken over by the DPP?
So our position is that it was taken over by the DPP,
right,
that it was unlawfully withdrawn. If the court rules that the purported withdrawal was unlawful, it was a nullity, it's as if it never happened.
Right.
And so the case is restored. Or we say the case never ended.
Hold on. Don't tell me about the case is restored. I am looking at page 5.
It never ended.
I'm looking at page 580, which is your application for JR.
Yes.
And order 4, you're asking for an order directing the respondents, not the DPP, directing the respondents who are the comptroller and who are Mr. Noel. Yeah? Directing the respondents to reinstate the prosecution of Dr. Hilaire. So you are asking for the respondents to reinstate the prosecution. But your case is that they do not any longer have the prosecution. They cannot therefore reinstate it. Help me there.
I don't have it in front of me. What page are you reading from?
Page 580 of the court about the CCJ's record.
580.
Yeah.
Yeah, Mr. Patterson, you can find it very easily in the Court of Appeal judgment. Paragraph 8.
I have it.
Yes, I think that's the easier way.
So the first thing we're asking is a declaration that the decision was ultra-various, irrational, unreasonable, arbitrary, made in bad faith, perverse, and was accordingly invalid, null, and void. So let's start there. If the court declares that it was invalid, it is as if it was never made.
Right.
And therefore the proceedings were never discontinued.
Right. But you're asking for more than that. You're asking for a quashing order, and you're asking for an order directing the respondents to reinstate.
And so my view is simply this: that was one of alternative reliefs we're seeking. But if you give the first relief, which is a declaration invalidating, a declaration that the decision to withdraw was invalid, that the purported withdrawal was invalid, then it is as if it never had happened.
Right.
And no order
reinstated
is required.
Hold on. A declaration that it never happened. Therefore what?
Yes. The proceedings are still on foot.
The proceedings by the DPP, according to you.
The criminal prosecution of Dr. Hilaire is still on foot.
That has been taken over, according to you, by the DPP.
Correct.
So therefore, it is not for the comptroller to do anything.
Agreed.
It will be for the DPP to do something. Yeah?
Well, we would have asked for relief in the alternative.
Alternative to what?
To the declaration of
no.
That
is with respect. That is not an alternative. That is a further order.
I believe that reliefs were some of them were alternative reliefs. In other words, so Milad, if you have declared that the decision to withdraw
Was
and the
bad.
subsequent withdrawal of the proceeding was a nullity.
Right.
If it was a nullity, it never
Right.
happened.
So what happens?
Then the case that was purportedly withdrawn remains on foot.
I understand that.
There is
So what
no
happens?
need in those circumstances for the further order directing the respondents to reinstate the prosecution.
But they can't, because
Well,
it has been taken over, according to you, by the DPP.
I accept that.
Therefore, you cannot get this order against them on your thesis.
But we could get an order. If it were necessary, we could get an order for the reinstatement of the prosecution, which is the focus.
Sorry, by whom? By whom? An order for the reinstatement of the prosecution by whom? It's
If
a
it
court
were-
order you're
Yes, we're saying if it were necessary,
right.
then the court certainly has the power to order the reinstatement of the prosecution.
The reinstatement by whom? This is what I'm trying to get clear.
Well, the Customs Act invests the comptroller with the power to prosecute. The extant prosecution was purportedly discontinued by the Comptroller of Customs.
Right.
We say it had been taken over by the DPP, but its source is still the Customs Act. It's still a prosecution initiated under the Customs Act.
I see your difficulty in answering me, and I will not push you any further. I'm content to leave it there.
I don't know that there is a good answer.
There is a good answer. There is a good answer. The good answer is that you should have joined the DPP and get certiorari and mandamus against him to proceed with this prosecution.
But the DPP has not. The
Said that he
DPP
has taken over.
not terminated anything.
Right.
The
And
DPP's
therefore,
position
the DPP
is
simply standing by, allowing this nullity to have effect, and the DPP is not proceeding with a prosecution which has not properly been discontinued. Therefore, it is for the DPP to now go and say, magistrate, I'm asking you to reinstate this prosecution or this case, which on the record has been withdrawn, and I, the DPP, want to take it further. That's what you need.
I don't know that the DPP can do that.
I don't think so either. So we are.
That's why that's where we're seeking to invoke the powers of the supervisory powers of the court. Only the court could provide us with the type of relief that we're seeking.
Patterson, don't let me detain you any further.
If I may take you to another area of inquiry, Mr. Patterson, of interest, not on this, moving away from.
Sorry, before you go there, brother.
Yes.
I think our sister wanted to provide an intervention. I don't know if it's on this point.
Thank you, Chair. It's not on this point. I wanted at some point to revert to the interpretation of Section 73(4). So if my brother wants to tie up an inquiry that he started, then I want to return to Section 73(4) of the Constitution at some point.
No, I'm moving completely away, so please go ahead.
Okay. Mr. Patterson, I'm inquiring into this. You had stated earlier that if no power is expressly conferred to discontinue proceedings, if no power is expressly conferred on a person or authority other than the DPP, right, to withdraw or discontinue proceedings, the matter must be referred to the DPP. I think you made that statement earlier. And so what I wanted to follow up on is, could you explain to me then the circumstances in which you think Section 73(4) would operate? Because I understand you to be saying that if the power to discontinue is not expressly conferred, the only way the matter can be discontinued is if it's referred to the DPP. Have I understood your submission correctly?
That's my view, yes.
Okay, so if you have a scenario where a person has not been expressly conferred with the power to discontinue, are you saying that section 73.4 would be inapplicable to that scenario?
I think that section 73.2 would apply, which is the power expressly conferred on the DPP to discontinue any proceedings commenced by another prosecuting authority.
Okay, so you're saying that section 73.4 is requiring a person who has been imbued with the power to withdraw proceedings, a person other than the DPP to withdraw proceedings, to only do so with the leave of the court.
That's correct.
So you're saying section 73.4 applies whether or not the officer has been imbued with the power to withdraw.
I'm not sure I understand that last statement. Section 73.4 applies where a prosecuting authority has the power to discontinue or withdraw proceedings commenced
express power.
Express power.
Express power, yes.
So your submission then is that even if the leave of court had been granted, that would not have allowed the comptroller could not have initiated withdrawal, because you're saying that section 73.4 could only apply to a functionary that had been expressly conferred with the power to withdraw.
And was lawfully exercising that power. So if the power in this case was subject to the overriding discretion of the DPP, as for example, in this case, where the DPP has taken over the prosecution, that power that the prosecuting authority had is removed from him. He can no longer lawfully exercise it because it is supplanted by the powers of the DPP. So even though he has the power to withdraw, it is subject to the overriding discretion of the DPP. If the DPP takes over the case, then that power is no longer exercisable by him. And so you don't get to the leave stage. And so
Thank you.
I qualify it by saying it is subject to the lawful exercise of a power expressly confirmed.
I just to tie that point up, I suppose then private prosecutions would also be included in that category of 73.2. Is that what you're contending?
73.2, not 73.4, because a private prosecution doesn't fall within the scope of 73.4.
Yes, just wanted to be clear.
On this question, on this matter of interpretation of section 73 at large, particularly 73.4, Mr. Patterson, in other parts of your submission, you said that the Constitution must be given a large and liberal construction. I believe you argued that.
Yes.
And looking at 73.4, the proviso part says this: provided that where any other person or authority has instituted criminal proceedings, nothing in this subsection shall prevent the withdrawal of those proceedings by or at the instance of that person or authority and with the leave of the court, unquote. Now, let me return to provided that where any other person or authority has instituted criminal proceedings, nothing in this subsection shall prevent withdrawal. It looks like me that you're telling us that, yes, there is something in this subsection that must prevent withdrawal, and that's something in this subsection that prevents withdrawal is the power of the DPP to take over and discontinue. Provision is saying, no, nothing in this subsection, including that, shall prevent the power, shall prevent withdrawal. Am I reading it the wrong way? Are you reading into it, first of all, something that is explicitly forbidden by the provision? And secondly, even if we didn't have that, is it large and liberal construction of the Constitution to say a prosecuting authority who suddenly decides, look, this case should not continue for whatever reason, should not go to the judge and say, look, I want to withdraw this case, give me leave. And you say, but they cannot do that if we don't see a statutory provision somewhere that allows them to do that. Is that liberal construction of the Constitution?
So
Those two questions.
Yeah. So we've argued that Section 73.4 provides that the Section 73.4 is there out of an abundance of caution. It does not confer a power to withdraw.
But it makes an allowance, though. It makes an allowance.
It only treats to those scenarios where the power to withdraw exists. We've also argued, when you look at the first part of 73.4, it says the powers conferred on the DPP by subsections 2B, which involves the takeover and continuation, and 2C, the power to discontinue. It says that those powers shall be vested in him, the DPP, to the exclusion of any other person.
But proviso says that provision, nothing in that should prevent withdrawal if court grants leave. Isn't that the way to look at it?
So the way we argued that is, if the DPP has not exercised the powers under 2B and 2C, and if the prosecution authority has the power to withdraw, then the fact that this section says the power to withdraw or to discontinue is to the exclusion of everybody else will not prevent that person from exercising that power. But where the DPP has exercised the powers on the 2B and 2C, then the power to withdraw or discontinue is excluded. And the Court of Appeal agreed with us. The judge at first instance agreed with those submissions. And the judge of first instance and the Court of Appeal both said, if the DPP has taken over pursuant to Section 2B, then a prosecuting authority can no longer withdraw.
That's a fair point.
That's what they've said.
If there's the evidence to that effect that the DPP has taken over. But the thing is that the courts below said, no, we do not find that evidence that the DPP has taken over.
And that's the crux of this appeal.
And
they say not only the courts below said that there was no evidence. And we said two things to that. One, clearly there was evidence. And two, it was not for the court at first instance at the leave stage to make conclusive determinations on fact. What they were supposed to do is to satisfy themselves that there was evidence capable of leading to that conclusion. And we say the evidence was there in spades. And the court ruled there is no evidence, not just we don't accept the evidence. He said there was no evidence at all, in spite of the fact that Chico sent a letter to the DPP saying, here are all the files which are being transmitted to you for onward prosecution. That's what Chico said. It's his direct evidence. He produced the letter, it's in evidence, which says, here are all the files for onward prosecution. And then what happens? The DPP then appears in court on 7 occasions and attends 1 mediation session.
I mean, DPP's counsel, lawyers from the DPP's department.
Yeah, the DPP's office.
And the court below did not accept that as amounting to evidence that should enable them to conclude that the DPP had taken over. The question there is there a difference between secondment and takeover?
I don't know that there was any issue of secondment. what Peter's evidence was, Chico's evidence was, is that he worked with the DPP in bringing the case. Once the case was brought by his office, he then turned over the files to the DPP for onward prosecution. In other words, for the DPP to take over. Chico testifies in his affidavit that the DPP, in fact, took over the case. It's his direct testimony. He was comptroller at the time. He initiated the prosecution. So he should know whether he's prosecuting it or whether the DPP is prosecuting it. That's direct evidence. The point we are making is at the leave stage, the court was not entitled to disregard that evidence, nor was it entitled to make findings of fact. That could only be made at trial if the case got there. And so we're saying there was before the court sufficient materials on which a conclusion could be drawn that there was enough evidence of the fact of the takeover of the case by the DPP. There was enough to satisfy the threshold test, in our view. There was evidence. More importantly, the court said there was no evidence. And so this court has to examine when the Court of Appeal and the High Court judge says there was no evidence of the takeover. Well, how do you treat with the evidence of Chico? How do you treat with the letters? How do you treat with the fact that the DPP appeared in court on 7 occasions at the request of the comptroller, who said, I turn over the matter to him for prosecution?
One difficulty.
That's evidence.
One difficulty here, as you would have gleaned from the questions of my brother Justice Barrow, is, of course, there is no issue being made about standing here to argue the complaint of the DPP. The problem is that the DPP is nowhere to be seen. You did not bring the DPP in.
We can't bring the DPP.
And the DPP has not intervened to say, hang on, this is my case. What are you doing? Withdrawing it. We don't see that evidence.
We can't bring the DPP at this.
Why not, Counsel?
We're at the leave stage.
But why not bring JR against the DPP?
Well, against the DPP, no.
Yes.
We don't have a decision of the DPP that we're challenging. We have a decision of the comptroller that we're challenging.
With respect, Counsel, what you are asking for is for this prosecution initiated by the comptroller to proceed. That's what you are asking for.
No, with respect, Melody, we are challenging a decision of the comptroller. That's what we're doing. We're challenging a decision of the comptroller.
It is not for me to tell you anything further. Thank you.
Now, I wanted to move you away earlier to the decision of the controller. Let us assume now, let's move, if we're at a stage or we get to the point where one would look at indeed whether or not the controller was entitled to decide to discontinue the case. The question arises, doesn't it, whether we're looking at a duty to prosecute versus the exercise of a discretion which two comptrollers may well have variant positions on. So first question to you, are we now dealing with a duty on the comptroller to prosecute, so that even if the controller says, no, I don't want to continue, you say, no, you must? Or are we dealing with an exercise in discretion, prosecutorial discretion?
So I think we're dealing with both with respect, and let me explain why. Where the law confers a power, an important power to prosecute, where a crime has been committed, and the authority that's vested with the power to prosecute that crime is aware of the crime, goes as far as to initiate the prosecution and then arbitrarily, irrationally, unlawfully discontinues that prosecution, we're saying the courts have a supervisory jurisdiction by way of review. In terms of a prosecutorial discretion, there's a dichotomy between the discretion that's vested in the DPP and the discretion that's vested in what we say are lesser prosecuting authorities. And so while the courts have consistently said that it will sparingly exercise its supervisory powers over the DPP's prosecutorial discretion, we say that those principles don't apply with equal force to a lesser authority, in particularly one that is not independent of the executive. And when you look at all the cases involving the DPP, it is the character of independence that sets it apart from other prosecuting authorities. The Comptroller of Customs is a member of the executive branch. He's not, by definition, independent of that branch. The Constitution, on the other hand, imbues the DPP imbues him and assures him the quality of independence. He has the power to the exclusion of all others, and he is not subject to the direction or control of anyone. That's what the Constitution says. There's no such provision in relation to the comptroller. In fact, the comptroller's powers are subject to the DPP. That's what the Act says.
Now,
and so there are two different qualities of things. We say all prosecutors are not the same.
All
different
prosecutors
rules are not the same, and different rules apply. If you're dealing with the DPP, then the courts have traditionally deferred to the DPP's decision.
But after all said and done,
Yes.
whatever authority we're looking at, you would accept the proposition, don't you, that there is no duty to prosecute.
There is a duty.
There is
a duty to prosecute.
Where is that duty in the Customs Management Act? I looked at section 103, 102, 3. It creates an offense. Does not impose a duty to prosecute. Neither does section 119 contain a duty.
That duty is imposed by the Constitution and at common law. And we've cited the cases which say that where you've been invested with the power to prosecute, you have a duty to exercise that power properly. No,
properly.
In the case of the DPP has a discretion, even though a crime has been committed. He can say, well, a crime has been committed, but for various other factors, we are not going to prosecute. That's his indiscretion. And the reasons why courts defer to that is that the DPP, as the principal prosecutor of the state, is entrusted with that awesome responsibility and is expected to act independently and purposefully.
Now let's look at the facts of this case.
Discharge of its functions.
See where I'm going with this, Mr. Patterson. We're looking at the facts of this case. This is a case that started with a memo titled Investigation of Government Missing Property.
Yes.
Written by the Director of Finance.
Correct.
All right. In the same memo, the Director of Finance says, this matter was referred to me by the Cabinet Secretary under a memo titled Missing Government Property, quote unquote. Director of Finance continues and said, we reviewed the documents attached to the memorandum from the cabinet secretary. And yes, it does appear to us that property that looked like it used to be government property is now in the name of Dr. Hilaire. And then, but then that is based on reviewing the documents attached to the memorandum of the cabinet secretary. So it's not an independent call or observation. What appears to be an independent observation is a paragraph where the same director says, we have looked at the database of government vehicles. There is no record that this motor vehicle was acquired by the government or disposed of by the government. So far, so good. Now, still telling the story. Later on, Comptroller Chico asks Dr. Hilaire, well, can you produce the invoice for the importation of this vehicle, the commercial invoice? And back and forth, it was not produced. Prosecution starts, and the charge was what? Charge wasn't about investigation. It wasn't about missing government property anymore, but the charge becomes a failure to follow the directives of the lawful directives of the controller. So that is the charge, the three charges. I take it there were three instances of that. Request for information was not given, so three charges. All along, Emmanuel, Mr. Emmanuel, or
Chico.
No, Emmanuel was deputy at this time, was deputy controller.
Deputy, that's correct, yes.
Yeah, he was still there, but deputy controller at the time, senior person, said, look, I think we should not be doing this. Our focus should be on collecting revenue. He was not from day one enthusiastic about this prosecution. Did I get it right? Yes, and eventually he gets appointed the comptroller. In the meantime, there had been lawsuit against him, against the comptroller, was Comptroller Chico, which now becomes the headache of Comptroller Emmanuel when he takes over office. He decides now, I want to discontinue this case, settle the case against the controller, give back the vehicle, and let's be done with this. Lawsuit or prosecution, he never believed in to begin with, even before change of government. Does that about sum up a bit of the background to this topic?
I don't know how close he was to the investigation. What I do know is that the investigation was over a 3-year period that was done in conjunction with the DPP's office, who was advising the then controller Chico at all stages as to the appropriateness of the charges. The DPP obviously believed that it was appropriate, that the case was made out, the charges were filed, and the DPP took over the case on that basis.
Can you look at 742?
Sorry.
Look at Appeal Record 742, paragraph 37.
742?
Yes, 742, paragraph 37 of Mr. Chico's affidavit.
Yes.
Paragraph 37.
Thanks for pointing that out.
All right. Quote, Mr. Emmanuel was a member of the team and participated in the discussions leading to the decision to prosecute. He well understood the reasoning behind the decision to prosecute Dr. Hilaire, but had expressed his concerns about pursuing the matter because his view was that the responsibility of the Customs Department was only revenue collection, unquote. That is the affidavit, the attestation of Mr. Chico.
That's correct.
All right. So the controller Emmanuel was always there, knew why this thing was being done, but never believed in it to begin with. So the question arises, as far as discretions go, is Controller Emmanuel to exercise judgment to discontinue the case in the same way that Controller Chico exercised judgment to institute it in the first place?
The difference between the two is, and when you look at Emmanuel's evidence, you'll see the difference between the two is that Chico did not simply willy-nilly decide to file these informations. He took advice from the Attorney General's office. He took advice from the DPP's office. It investigated it for 3 years before bringing the charges. The DPP was brought in to take over the prosecution. Emmanuel, on the other hand, once he was appointed as acting controller and replaced Chico, decided the matter within a period of 2 months.
But he was always there, though.
But he decided the matter on a period of 2 months without any consultations. He said he spoke to 3 other officers in the department. We don't know who those were and what he said, but he took no legal advice. He took no advice from the DPP. He took no advice from the Attorney General's office. He simply said, well, he took advice from the Attorney General. That's what we say.
Okay.
Who was the lawyer for Dr. Hilaire?
Mr. President, are you about to intervene?
I am about to suggest that we might want to wrap up the presentation by Mr. Patterson. I did mention flexibility earlier, but I think we have gone a little bit. Did you want to just complete that round of questioning, Judge?
I do indeed. Mr. Patterson, on that point, taking advice from the Attorney General.
Yes.
Of course, Controller Emmanuel denies it, but let's assume that the question was consultation. I'm not sure that there's any evidence or that did you allege that the Attorney General told him anything. The issue, it seems to me from my reading of record, is that the concern was consultation with the new Attorney General, who used to be counsel for
Correct.
Dr. Hilaire, right? Is that enough? Let me tell you why I asked this question. One could see a number of possibilities. Tell me which one we have here. Assuming Mr. Emmanuel did indeed make that consultation, he goes to Mr. Mondesir. I said, look, I want to withdraw this case. Mr. Mondesir looks at him, says nothing, dead silence. That's one scenario. Second scenario, Mr. Mondesir changes the subject without addressing it. Third scenario, Mr. Mondesir says, look, I cannot advise you on this. This is your judgment. I used to act for this man. Fourth scenario, Mr. Mondesir says, yes, good idea, withdraw the case. What do we have in the evidence in any of this?
So what we have is the evidence of the impropriety of the fact of that those 2 meetings in the first place.
Is it enough?
If according to Chico, Emmanuel came to him and said, I need the files because I'm going to meet with Attorney General Mondesi to discuss the matter. That's what he said to Chico. Chico handed over the files and warned him listen, if you do this, you're treading on dangerous ground. He's conflicted.
Why do we assume that Mr. Emmanuel did not act on that advice? Be careful.
Because he told him that he met with the Attorney General. He told him. Emmanuel told Chico that I met with the Attorney General.
But did not
confirm that he met with him to discuss the matter.
I'm saying that even if we have the meeting between the two men, Mr. Montezir and Mr. Emmanuel, do we need more by way of evidence?
You are saying, Mr. Patterson, sorry, Judge, that you don't need more. The mere fact of meeting with the AG, who you say was convicted because of his previous relationship with Dr. Hilaire, is sufficient. Yeah.
Conflicted, and it would be improper for him to have met with the Attorney General to discuss the case. It would have been entirely improper. And that meeting by itself vitiates the decision, in our view, because of its impropriety.
Okay.
And it raises the inference of political interference.
And we see that very clearly in your submissions. We have kept you much longer than we had indicated we would. Is there any major point that you wish to make before we ask Mr. Astafan to address us?
Yes, I would be grateful, my lad, just to direct your lordships, because I'm now out of time. I haven't been able to direct your lordships to the cases that we have submitted. In the bundle, there was the case of the chief boss and Sons versus the Crown Prosecution Service. I submitted that case 2 days ago, I think, or day before. It's now in the bundle. It's in the bundle at page 622 of the record.
Okay.
And if you go to paragraphs 26 through 30 of that decision, and in particular paragraph 29, where the court says in the middle of that paragraph, there must nonetheless be a powerful argument that a court should apply a more stringent standard to prosecution policy devised and implemented by the executive government, as the deference to the DPP and other independent prosecutors is grounded on his constitutional independence of the executive government. Such a decision, when not made by an independent prosecutor, may be thought to be a little different to the other decisions of the executive government, and therefore subject to the same standards of review.
Okay.
So that's one case. And in the case of Crown versus Chief Constable of the Kent County, that's also submitted yesterday and can be found at 6629 of the record. And if you go to page 6639 of that decision.
You don't have to read the quotation there, just direct us to the page and we'll take it from there, okay?
So the quotation starts in RV General Counsel of the Bar.
Okay.
And you'll see where the judge makes essentially the same point, that you have a different standard that should apply to different. So it supports the argument we made that all prosecutors are not the same, and a different threshold applies to the DPP because of his independence.
We follow you on that. You know, want to be very useful, certainly for me, and I suspect my colleagues as well, is a case, or if there are cases, on the point first raised by Justice Osuji, that is to say, are there cases challenging the decision of the private prosecutor that is subject to leave by the court? Are there any cases in JR challenging such a decision? Are there cases
of a private prosecutor?
private prosecutor or public prosecutor, anybody other than the DPP. The question is there any such case that we can have a look at where the challenge was to the decision taken by the non-DPP prosecutor? I think that would be very, very handy.
So these two cases are examples of them. Okay, two
They're
cases
examples.
I just said.
These were non-DPP prosecutors.
Yeah, they were talking about, these were non-DPP prosecutors.
Okay, and they involved challenge to the decision by the non-DPP prosecutor to seek leave to discontinue the prosecution.
Essentially so.
Essentially, okay.
No, it doesn't deal with the leave point. It deals with the question of the threshold and the attitude of the courts towards reviewing decisions of a prosecutor. And so the point these cases establish is that when you're dealing with a non-DPP prosecutor, the same standard that applies to DPP will not necessarily obtain.
Yeah, follow. It's not quite on the same point that my brother raised, but we follow you. Okay, well, thank you very much, Mr. Patterson. That was very interesting.
President, before we hear Mr. Astafan,
yes.
we have a short break. I need to attend to something.
Absolutely. So shall we take a break then for
5 minutes is good.
5 minutes, and then resume at 11:42.
Thank you.
Thank you very much. Okay, I think we are ready to resume. Madam Deputy Registrar?
Yes, President, I'm seeing all the judges. I'm seeing counsel for the respondents. Are you all there? Yes, I'm seeing the balance. Yes, we can resume, President.
Thank you very much. Mr. Astafan?
Mr. President, thanks a lot. I intend to just deal briefly with all of the various issues that were raised. I would like to start with the question of the decision of the magistrate. I just wanted to point out at page 626 of the record that the withdrawal had taken place after mediation. So the magistrate had in fact ordered mediation, and mediation in fact took place. And following mediation, the withdrawal was made and the decision of the court was made. I just want to point that out. It was not just an arbitrary off-the-cuff decision by the Mr. Emmanuel and the magistrate. She would have presided over the mediation process. That's what. I would like to just refer, I know the court is very familiar with the principles of Sharma versus Antoine, but there's a paragraph that I think I need to bring specifically to the attention of the court. You will find it at page 379 of the bundle, at page 6205 of 6299 of the appellant's list of authorities. And it's this. In speaking of the litmus test for judicial review, the Privy Council said the test is generally low, but there are circumstances when a flexible test has to be applied. That's the context of a prosecutorial discretion and when very serious allegations are made. In this case, very serious allegations are made with very little, if anything, to support the allegations made. The Privy Council said this: the more serious the allegation or the more serious the consequences if the allegation is proved, the stronger must be the evidence before court will find the allegation proved on the balance of probabilities. Thus, the flexibility of the standard lies not in any adjustment to the degree of probability required for an allegation to be proved, such that a more serious allegation has to be proved to a higher degree of probability, but in the strength and quality of the evidence that will be in practice be required for an allegation to be proved on the balance of probabilities. In fact, we understand this decision to be saying if there's the context of a prosecutorial discretion with very serious allegations being made, evidence has to be clear and strong and sufficient to be for the judge and the Court of Appeal to be able to make the decision that there's a tribal issue with reasonable prospects of success, which is meeting the litmus test of the balance of probability. I just want
Mr. Estefan?
Yes, Your Honor.
We do not want Mr. Patterson to have the advantage over you of our having seen and continuing to see his features, whereas we are tending to see just the upper portion of your cranium. You might want to tilt your camera a bit. There you go, full splendor. Continue.
Yeah. Thank you, and I'm sorry about that. Initially, it showed me in the middle of the screen. I'm sorry. On the question of the independence of the prosecutor and the test to be applied, it's important that we make certain submissions in relation to the status of the first respondent as the person vested with the statutory authority to prosecute. We submit that section 119 of the Constitution is clear. Sorry, 119 of the Customs Act, which made the prosecuting power of the controller to be subject only to that of the DPP. There is nothing in the Act or any other legislation to suggest that the Comptroller of Customs acted on the decision or policy made by the executive, which would have influenced his decision to prosecute. The Moss case, which my learned friend read, is very clear. The executive branch had decided the guidelines for prosecution in relation to the dairies matter. In the customs case of Saint Lucia, the only authority to prosecute for offences subject to the power of the DPP is the Comptroller of Customs. And while Section 4 said that he's subject to the general direction of the minister in relation to the administration of customs, it does not extend to his prosecutorial powers under Part 11 of the Customs Act. More specifically, Section 119. So we respectfully submit Moss would not apply because there was no executive influence in relation to Mr. Emmanuel's decision to discontinue. In fact, as Mr. Justice Ebo, sorry, Your Honor, I can't pronounce your name.
You can say Osuji is fine. Osuji said the last
His Honor Osuji said that Mr. Emmanuel was of the mind long before he became controller that the decision to prosecute was not the right thing to do, based on all of the circumstances. And in his evidence in response to Mr. Chastanet, he said that he had reviewed again the documents within the control of the customs and was satisfied that the document that the Mr. Ernest Hilaire was in fact prosecuted for was in fact in the possession of the Department of Customs, and in fact he disclosed it in as part of the exhibits in his case. I'll get the page number for Your Honors in a short while. So we respectfully submit that the distinction between the Moss case and this case is of extreme importance. In fact, there's my learned friend has in his bundle the case of Blackburn, the great famous prosecution case, which speaks to the powers of the police to prosecute without interference from the ministers and from the executive branch. And in fact, this morning we sent up, albeit late, Mr. President, we apologize for that, the Privy Council case of APC Power Company in Antigua versus the Attorney General, where the Prime Minister had given directions to the Commissioner of Police to do certain things in relation to its operational features, far less its prosecutorial features. And the Court of Appeal agreed that the Prime Minister or the Minister had the authority to do that. The Privy Council disagreed. If you have a look at the case we uplifted this morning, and through Mr. Anil, we got it back with the page numbers. It makes it very clear. A member of the executive cannot give directions to the police officers in anything in relation to operations or prosecution. We'll also ask Your Honors to look at the Privy Council case of Stedroy Benjamin versus the Attorney General, others, I think Commissioner of Police and so on, where the Privy Council made the decision that overruling the decision of the Court of Appeal, that the DPP had the authority to direct or to require the consent of the police before any prosecution can take place. The Privy Council, relying on Blackburn, made it very clear that the executive branch has no authority to instruct the Commissioner of Police to prosecute, to investigate, to do any such things falling within its statutory powers. We respectfully submit that the same principle applies in relation to the Comptroller of Customs. And if I may ask you to have a look at the Moss case. That my learned friend relied on. I think it's paragraph 27 at page 6627 of 9626, where the very clear distinction is being drawn by the court between executive influence over the decisions to prosecute as opposed to other matters in the administration of the respective force. It says this: where the decision to prosecute is entrusted to the police, again, a broad discretion is afforded, as the police are in making such decisions and policies constitutionally independent of the executive of government and of any local authority or other official or office holder to whom the police are accountable in other respects. So it is saying that while the police may be subject to other aspects of their functions in relation to the administration of the force. When it comes to the prosecution, it is for the police to make decisions of policy for prosecution and to make the decision to prosecute. We respectfully submit that these cases ought to be helpful in arriving at the decision, as we submit that the first respondent is, in the exercise of his statutory discretion, an independent, quote unquote, prosecutor, similar to that of the police, because he has been given the statutory responsibility by Parliament to prosecute offences under the Act, subject only to the powers of the DPP. And we respectfully submit what that means is that at any time, consistently with the Privy Council case of Stedroy Benjamin, the DPP could take over a case at any time to either discontinue it or to prosecute it. What it cannot do, what the DPP cannot do, is to instruct the police or the customs not to prosecute matters unless they consult with him or seek his consent. And I respectfully submit these decisions to your Honor. I don't need to read them because I take it for granted they've been read. On the question of the discontinuance,
Mr. Astavan, before you continue, on that issue of the DPP, in the role of the DPP in this case, I mean, as you know, that's been a live debate on whether or not the DPP did in fact take over. I'd like to know what evidence we have in that regard to say the DPP did not take over. What should we be looking at? I know in your submission somewhere, you did say, well, it is part of the practice for DPP staff to be, in effect, seconded to when prosecution is domiciled in other departments. So DPP start being the specialist. Prosecutors can be seconded to assist, but that doesn't mean a removal of the domicile of the prosecution from that other department to the DPPs. So the question I
I'm sorry, Your Honor. I'm sorry. I didn't mean to interrupt you.
Fair enough. So the question then becomes, what is the practice for when the DPP does in fact take over a prosecution started by other authorities? What is the practice?
Well,
how do we know that?
I have two responses. The question of the practice in Saint Lucia of the Attorney General and the DPP advising customs and the DPP's office providing prosecutors to assist the Comptroller of Customs is not in dispute between the parties. In fact, it was agreed, and the High Court and the Court of Appeal drew the distinction between a takeover of the proceedings by the DPP and providing assistance as and when requested for specific cases. We submit that the practice did not constitute a takeover of the case, because it still remained in the name of the first respondent, Comptroller of Customs.
So when you say it still remains in the name, would it be the case that when the DPP has taken over, I'm sure Mr. Patterson also will get to this in his reply if he wants, but would it be the case that when the DPP takes over, we will see a change of style of cause in the case from maybe Comptroller of Customs or a named customs officer versus the defendant? It becomes the DPP versus the defendant, perhaps DPP in ex parte, the comptroller, whatever. Do we need to see the DPP's name on the style of cause? Is that one is basically I want to know how we are to know whether or not the DPP has taken over or not.
Well, that's a great question, Your Honor, and it was dealt with in the Privy Council case of Stedroy Benjamin in paragraph 27 of the judgment, when the Privy Council said that you cannot clandestinely or secretly or in the middle of the night say or allege that you've taken over the case You have to do it in a public way, where the public is informed, where the magistrate is informed, where the parties are informed. Otherwise, people will be deprived of or denied their potential rights of challenging the takeover or any decision the DPP may make.
Is that too strict a standard to set, though? Is that too strict? I mean, there used to be, I mean, some of you, I'm sure, yeah, international law, there used to be a time when you had to have declared war for people to know you're at war, but international law moved away, so you do not need to declare war. It's all in what you do. But it's not only in international law, you know. Equity, we're familiar with that expression, that equity looks at substance and not form. What is it here?
Can I add to that, Mr. Stefan? Is that indeed the practice in Saint Lucia? That if the DPP takes over a matter, that the DPP's name will then be placed on the cause as against the Comptroller of Customs?
Technically, yes, but not.
Once it's an indictable offense or gets to that stage, I'll have to get instructions from my Saint Lucian instructing attorney, madam. I don't have the answer. But the point I want to make in Antigua, it was not the practice for the DPP to publicly take over proceedings and so on. But in the specific case of Mr. Benjamin, the Privy Council made it very clear that constitutionally, justice has to be dealt with in the full array of the sun shining on the table. And that the DPP needs to make a public statement and a public declaration to the court and others that he took. There's nothing like this in this case. In fact, in an answer to the learned president, who asked whether there was any formal response to the DPP, to Chico's letter to the DPP, there was in fact none, zero. And the other point I wish to make, relying on Chico's evidence, Chico attended the mediation process at least more than once. On the day the cases were withdrawn and the magistrate made its decision, Chico was present. He then says he went to the office of the DPP, and the DPP was furious. And if I may just read a short note I made, Mr. President. I said Chico made allegations in paragraph 32 of his affidavit at page 741 of 2925 about the DPP's hostility, etc., towards the first respondent after the dismissal of the charges by the magistrate. He alleged the DPP complained loudly to the first defense respondent, among other things, that you didn't consult my office and had no decency by not having a discussion with Chico. Importantly, we submit, this is the DPP that my learned friend says took over the case. In that exchange with Mr. Emmanuel, the DPP made no mention of having taken over the case constitutionally, and therefore he, the first respondent, would have had no authority to withdraw or discontinue the proceedings. The DPP's alleged complaints were no consultation with his office and no discussion with Chico. Now, that's extremely important, because you would have expected in the evidence before the High Court and the Court of Appeal that the DPP would have said, I took over this case. Here's the document that showed I took over this case. You had no authority, and you knew it. And you had no authority to discontinue the matter without consulting me. But that's not what he said, Your Honors. He complained about consultation, the very same thing that the Privy Council frowned upon in the Sedgwick Benjamin case, which I implore Your Honors to look at, that the DPP has no authority to demand you consult with him, to be directed by him, or to require his consent to prosecute to exercise the statutory power of prosecution. They are to that extent independent of the DPP, except when he decides to exercise his discretion to take over a case and to prosecute it. And we asked this Honorable Court to make a similar finding to which was made in the Privy Council, that if it had to be done, it had to be done openly.
When you started, Mr. Astafan, I think one of the points you were making was that the non-DPP prosecutor is an independent prosecutor, and that his status is aligned somewhat with that of a DPP, and the same kind of regard should be given to the non-DPP prosecutor. Do I have that roughly right?
That is right, but I could modify it. I could say even if he's not comparable to the DPP, because it
Right.
constitutes, it involves a prosecutorial discretion. Similar principles ought to apply, even though this level of scrutiny may be slightly different. But the fact is, the same principles should apply. For example, irrelevant considerations would not be used as a basis to set aside the decision of the DPP.
Understood.
In this case, I'm sorry, Mr. President.
No, please go ahead. Yeah.
Okay, basically, that's what I'm saying. And especially, and I think especially, the court ought to take into consideration that this case involves politicians on both sides of the divide. The former Prime Minister and Leader of the Opposition, and now Deputy Prime Minister.
No, where I was going with what I raised was the fact that there is a distinction between the DPP and the non-DPP prosecutor. And that distinction, I think, came up in the questions asked by my brother, Justice Osuji. The point is that the non-DPP prosecutor has to have leave of the court to discontinue, withdraw criminal prosecutions. And you would have seen, of course, that occupied much of our interactions with Mr. Pattison. I wanted to get your view on that thesis of the case, which was provoked by the questions by my brother. What do you think of that hypothesis? That once the court or magistrate has given leave, the effective decision is that of the court, and therefore a challenge to the process ought to occur in relation to the decision by the court. Did you have a view on that?
Yes, I do, Mr. President. I was going to make, maybe my agenda is wrong. I was going to deal with that last, because I realize it's the most important question. We agree with the fact that the question, the decision that should have been challenged was that of the magistrate. In fact, we raised that in the Court of Appeal, and you'll see the Court of Appeal made a finding in paragraph 91 and others that the applicant had not applied for leave to set aside the decision of the court. And we respectfully submit that the provisions of section 72(4) of the Constitution. May I just turn to my right to look at my file, Mr. President?
Yes, please, yes.
That the provisions of the Constitution, as we've been told from the days of Keeville and law school, needs to be construed purposively, especially some of the judgments of the CCJ, broadly, expansively, to protect the rights of individuals and so on. And we respectfully submit the same principle should be applied in construing 73 subsection 4 of the Constitution. What it says, and it in effect gives the right to apply for the leave of the magistrate to discontinue the proceedings or whatever the situation may be, by saying that any person other than the DPP who brings any prosecution would have the right to approach the court and inform the court of their intentions, and the court will have to make a decision on that matter. And it did make a decision on that matter. And in fact, it went further, as Mr. Justice Dennis Barrow pointed out, made a consequential order, ordering the return of the vehicle. And as far as the magistrate was concerned, that would have been the end of the matter. In any event, that was our primary argument in the Court of Appeal. The provisions of the Constitution itself gives a right to anybody who institutes any proceedings to apply to the court to have it, to apply for the leave of the court or to inform the court of the thing. The Constitution provisions do not draw a distinction between implied rights or express rights of discontinuance. It itself provides a mode of discontinuance for those who have filed criminal cases. But we would also say, to the extent that it may be necessary to find an implied term, independently of section 73(4) and the proviso, which we say creates a right to apply. We submit that the Court of Appeal was correct to say that section 17(3) of the Interpretation Act would be a plank upon which we could have launched an argument that there was an implied or incidental right to prosecute.
Mr. Estefan, on that issue, how do we get there? How do we get to pulling or involving section 17(3) of the Interpretation Act in all of this. Section 17.3, when you look at it on the face, says he or she who has the power to do something should also have the power to do that which is necessary to accomplish the primary power. So I'm giving the right, or rather the power or the mandate to sweep the street, but no one says I'm going to do it. And I decide I need a broom to sweep the street. So that's an incidental power to get the broom. How do we get to a point where, well, incidental power becomes the power to not sweep the street or to undo that which the primary power confers? So I'm looking at section 17.3, and I'm trying to find how a power to do something has an incidental power to stop doing that, to undo that.
Well, our argument was, which was accepted by the court in the alternative, was that the power to prosecute without the incidental or implied power to discontinue the prosecution that you have started would make more sense than to leave it without the implied power to prosecute. Like the power to clean the yard may carry the implied obligation to do it properly. But our primary case has been that section 73.4 and the proviso separated the provisions relating to the DPP and created a separate method or right to seek to discontinue by seeking the leave of the court, whether you had an express right or implied right or not. That's the way that constitutionally we ought to construe these provisions. Otherwise, so
your argument is that your primary argument is that section 73.4 is large enough to accommodate the facility of withdrawal for non-DPP prosecutors. You're saying that's your primary argument, but alternatively, then you say, well, if that doesn't work, maybe we should look at 17.3 as well. Do I understand that to be the orientation of your argument?
Yes, Your Honor.
Right.
That's our case.
Yeah, Mr. Astafan, I want to get your take on things that had been, some issues that had been considered by both Justice Osuji and Ononowu earlier, and that has to do with the proviso itself. Are you of the view that if this prosecution had been taken over by the DPP, as argued by Mr. Patterson, that in those circumstances, this proviso would have allowed the controller to withdraw those proceedings, but with the leave of the court?
No, my lady, to be honest with the court, had the DPP constitutionally and properly taken over the proceedings, I do not think, and the Comptroller of Customs was officially informed by notice and the courts and everybody else. I don't think we could reasonably or safely argue that despite that, we still had this right of going to the court to have it removed.
I see. So what did you make of that which Justice Osuji emphasized a short while ago, that provided that where any other person or authority has instituted criminal proceedings, nothing in this subsection shall prevent the withdrawal, etc. How do you read those words, and you say purposely?
Well, Your Honor, if you look at section 73B, I may have it wrong.
2B?
2B, that it can at any time take over criminal proceedings instituted by any other person or thing. So I think that it, as shown in the Privy Council case of Benjamin, the DPP could at any time take over existing proceedings brought by any other authority or person, and either nullly discontinue it or continue the prosecution. all that we are saying for the provision of this case, the proviso applies because we have said, and the courts have concurrently found, that there was no sufficient evidence to suggest that the DPP had taken over the proceeding. And what happened was more likely consistent with the existing practice of sending prosecutors or giving advice for prosecution.
I follow you. I take it that you put your eggs in that basket and you're happy with it.
I think it's a better basket for me.
Thank you.
So, Mr. President, have I given sufficient responses to that issue?
Yes, I think you have. I suppose the only issue that bothered me, and I think this was raised by Mr. Patterson, is that if you take the view that what should be challenged is the court's decision, then we never get to a position where we can examine the decision taken by the non-DPP prosecutor.
Yeah, but
so I wondered how you would respond to that. Yeah.
Well, I'm sorry to interrupt you. It's very simple. The fault is not that of the court. It's not that of the respondents. The appellant was put on notice with the application, with the notice of objections for the leave to apply for judicial review, that we had taken over this matter, and we got the leave of the court, and no amendment was made. No decision was made to challenge it. It was not raised in the High Court. It was only raised in the Court of Appeal when we were making these submissions. Or they may have made the submissions in the Court of Appeal. That's the first time it raised its head. And I don't think the CCJ should feel any way about making a decision whether or not they believe the appellant was the one who made the error by not pursuing it. Because Chico, if I may point out, Mr. President, Chico was present at the mediation, as you can see in paragraph 31 of his affidavit. Then he went to the DPP with Mr. Emmanuel. They had this big thing where the DPP complained about everything else except the fact that the controller had taken over his matter. Because that was our primary argument, and in fact, the Court of Appeal said that that point was not open to them in the Court of Appeal, and it ought not to be open to them in the CCJ. But if the CCJ is minded to look at it, it should be whether or not the DPP had in fact taken over the case. So it's not the false court, it's not the respondent's fault for not having challenged the decision of the court earlier clock. And it's not to say that we ambushed them. We didn't. We put it in our notice of objection and we raised it in the Court of Appeal.
Yes, I follow. I was thinking more generally that the decision of the court, when challenged, that challenge could perhaps also include any defects in the decision-making process of the non-DPP prosecutor, so that you would not lose the opportunity entirely of examining any deficiencies, defects in that process. And that is what I had put to Mr. Patterson. But in this case, I take your point that we're looking at something different. That is to say that the matter wasn't raised when it could have been, perhaps, and therefore you're saying it ought not to be raised at this stage.
Correct, Mr. President.
Yeah.
Hold on.
Forgive me, President, just for clarity, which matter was not raised? And I didn't follow my learned friends, just with assistance of the court.
I think it's supervisory.
The Court of Appeal ruled that the issue of the leave of the court is not open to the appellant because they had not taken the point before the judge.
Yeah.
That's a section 91, paragraph 91 of the judgment, where the point is made clearly that no application was made to challenge the decision of the court. And that's not our fault, and that's not the fault of the court. Is there anything, Mr. President, I could assist the court with?
Not further than that point, no. Did you want to move on to something else?
Well, I've already. Could I just have a second to talk to my instructing counsel, Mr. President? 1 second.
Mr. Esteban, just so that I am clear, because like Mr. Patterson, I was trying to figure out which issue, which point should not be raised now. So you're saying that this court ought not to look at the issue of whether leave was properly granted by the magistrate, or whether Section 73(4), the proviso, has been complied with. Is that how I understand your argument?
No, I was putting the argument how it came across in the Court of Appeal. I think it was raised in the CCJ, and for the guidance of the public interest, it may be necessary for the CCJ to look at that point. That in fact, the challenge should have been to the decision of the magistrate's court. They've raised it in the CCJ. We have not objected to them raising it in the CCJ.
Okay, thank you.
I hope I didn't confuse the court.
So
Mr.
let me be
President,
clear.
you're
Are
mute,
you saying what I'm trying to get at here? I think I understood you when you said it's not the fault of the respondents, it's not the fault of the court. Do I take it you're saying, well, if the appellants had so far driven the wrong train, let me put it that way, that CCJ is not obligated to get on that wrong train. If CCJ feels that this is a matter that should have been more appropriate if it was an attack against the leave grant, instead of focusing the attack against the controller. That if we take the view that this should have been an attack against the magistrate, we are entitled to make that decision.
I hope I'm not confusing the court, because this has been a difficult issue for us to deal with, to be frank with the court. The CCJ can look at it and indicate that the wrong decision was challenged. It should have been that of the magistrate's decision. The problem is if the CCJ does, I may be modifying my position on my feet without instructions from the AG, but I think I'm entitled to do that at this stage. To modify the point to say, well, look, you challenged the wrong thing, and we are saying you should have challenged the magistrate's order. In these circumstances, the appeal would have to be dismissed, because the decision that terminated the proceedings was not that of the DPP, was not that of the Comptroller of Customs, was the order of the magistrate's court. I hope I'm a bit clear.
The further point, Mr. Estefan, occurs to me from what you're saying is that if the decision of the magistrate to allow the withdrawal to have effect was being challenged, then the magistrate could have provided reasons for decision or whatever it is in relation to a challenge to the magistrate's decision, whereas now what is before the court, what is being considered, is simply incidentally whether there was an application for leave to the magistrate to withdraw, whether the magistrate considered that there was implicitly, perhaps explicitly, one doesn't know, an application for leave to withdraw, and what the magistrate decided consequent upon that application for leave to withdraw, clarifying the framing of the order, which is it is adjudged and ordered, but also that the matter is withdrawn. So it seems to me, if the magistrate's decision had been challenged, then those matters would have, as a matter of record, necessarily been brought to the fore. Am I correct?
Yes, Your Honor. Mr. President, is there any other issue I could assist the court with?
I'm not clear if any of my colleagues wish to raise any other issue. There's none that I want to raise, no. And I don't see an indication that anybody else wants to raise an issue. So I think we'll thank you for your presentation, Mr. Astafan.
Thank you, Mr. President.
Thank you. Mr. Patterson, did you wish to make a reply?
I do, Mr. President. If I could just start from where my learned friend left off. He said that the issue of the magistrate not granting leave for from our perspective, the issue of the comptroller not seeking leave of the magistrate was raised for the first time in the Court of Appeal. That is absolutely incorrect. If I take you to page 5194 of the record, which is the transcript of the proceedings before the first instance judge, from line 14 of 5194 to line 15 of 5195, you will see that we deal with that issue extensively before the High Court judge.
What lines again, sorry?
From line 15 of page 5194 to line 15 of page 5195.
That's the section that begins, and so is the process of mediation itself fundamentally flawed.
Correct. You'll see
because it lacks any legal authority.
Right. It says quite apart from that question, which really isn't the focus of the case, because we're not here trying to interrogate the actions of the magistrate. Because as far as we're seeing, the magistrate recorded as an administrative function the fact that the comptroller had withdrawn the case. That's all he did. I don't see the magistrate adjudicating anything. It was announced to him that the matter was withdrawn. He recorded that fact. But constitutional proviso they rely on requires more than the magistrate simply performing an administrative function and so on. So you'll see that I deal with the specific question there. My learned friend took the court to Stegroy Benjamin and is relying on that argument, that case, for the argument about the public way in which the DPP should have taken over the proceedings. If you look at paragraph 27 of that decision, which is at page 416 of the record, you'll see that one has to read carefully the context of those remarks about publicly visible step. In that case, the issue there was whether or not the DPP can prevent a private citizen from instituting proceedings. The board said he could not, and in that context, it said, is it indeed absurd for the power to discontinue not to be matched by a power to prevent? The director exercises his power to discontinue by taking a formal publicly visible step in the proceedings which can be challenged by judicial review. An instruction by the director to the police not to institute proceedings would also be, in theory, be susceptible to judicial review, but would often lack the public visibility which would alert potential applicants to the possibility of challenge. So when you read those comments in that context, what he's saying is, the court is saying is simply this. If proceedings are pending and the DPP wants to discontinue them, well, he can't do it in secret because he has to announce the discontinuation to the court. It can't just happen in a back room and that's the end of it. Whereas if he gives directions not to prosecute, that can happen in a back room. There's no public visibility and the public won't have the opportunity to challenge that. That's the only context in which it doesn't support the proposition which they have been asserting and which the Court of Appeal apparently accepted, that a DPP must do it in a public way. This simply recites the fact that when he's discontinuing, he does it in a public way. When he's prosecuting, he does it in a public way for that matter, because you can't prosecute in private, you can't prosecute secretly. The mischief that this paragraph seems to suggest is that where the director is giving instructions to the police not to prosecute, that can take place out of the public glare, and there's a mischief about that. Those aren't the facts here. This was a discontinuation that was done by the Comptroller, not by the DPP. The taking over was done publicly because he then appeared on 7 occasions. His office appeared on 7 occasions at the request of the then Comptroller, who handed him all the files, which suggests he's no longer involved in the prosecution, and said, please take over from here for onward prosecution. So that's a matter of fact that should be determined at trial, not at this stage.
Isn't that a bit dangerous, that proposition that you're advancing for your cause? That the DPP's office appeared on at least 7 occasions at the request of the Comptroller. The Comptroller could not have been requesting the DPP's attendance or his representative's attendance at the trial because it was the DPP's case and no longer the Comptroller. So I find it a bit awkward to think that the DPP was sending his counsel to, as it were, represent the Comptroller in a case which the DPP had taken over. Help me there.
Our position as a sequence is different. The Comptroller had control of the case, then requested the DPP to take it over. The DPP took it over. So once the DPP took it over, then it was the DPP's case. So we're saying in January.
It was no longer at the request of the Comptroller.
No, it was it's the request of the Comptroller that initiated the decision of the DPP to take it over.
So he took it over. He having taken it over, yes. It could no longer be that his counsel were appearing at the request of the Comptroller because it was the DPP's case. Is that correct?
Correct. It is the DPP who took over, and as a result of the request of the DPP took over at the request of the Comptroller. Having taken it over, the DPP's officers appeared in the matter being conducted now by the DPP.
I think that's a much more helpful formulation for you.
Yes.
Mr. Patterson, could you respond to the question that was initially raised by Justice Ebo Suji with respect to the practice in Saint Lucia in circumstances where the DPP takes over a case? Are you in a position to respond to that?
I'm told by counsel who practices in Saint Lucia, co-counsel Mr. Mirage, that there is no practice that the name of the prosecuting party changes. That's my understanding based on what he has representing to me. Obviously, that's not evidence, and I'm not myself familiar with the practice.
Mr. Patterson, on the transcript you referred us to earlier, page 5194 of the court record, right at line 14, that you referred us to. It says, and so is the process of mediation itself fundamentally flawed because it lacks any legal authority. I'm interested in mediation now. It features quite a bit in this case in the record of the court we saw earlier at 6 to 6 and so on. Mediation, the purpose of mediation is to settle a case, isn't it? Is that understanding correct?
That's my understanding in a civil context. The question we were raising here was, is there provision in the law for mediation in a criminal context?
Fair enough. So you're saying that there's no provision for it, so it should not have taken place.
Well, we couldn't understand the basis for it.
But generally, the purpose of mediation is to settle a case.
I understand that to be the case, yes.
Fair enough. And when did you say the election took place again that changed the government? Sometime in July. Do you know the date?
July 2020.
What precise date in July?
Mr. Astafan might be better able to
The new
assist
Prime Minister took over on the 28th of July.
On the 28th. All right. The reason I ask this question is this. There was a mediation on the 28th of June. That was before the change of power. And at that time, Comptroller Chico was in charge.
Correct.
So mediation on 28th of June. And he attended that mediation. And at no point from the record did I see any challenge to the legality of that mediation. He attended on that date and attended again on the 6th, I believe, of July, if I'm correct.
I'm aware of the 28th, and then I'm aware of one on the 1st of December.
Yeah, I think there was one. There was another one in July, apparently 6th of July, where Mr. Mondesi and his team did not show up, and the question was, where were they?
That's correct.
The mediator made a phone call, said, well, the election was promptly called, and they forgot all about the mediation. Okay.
Yeah. So it's an aborted mediation. That was an aborted.
So that was on the 6th. So before the election.
Before the election. That's correct.
All right. So 2 mediation sessions before the. So would it be correct to say that efforts to settle this case were well afoot before the change of government, and Mr. Chico was part of that? He was attending them.
I think Mr. Chico's evidence was that he was trying to get the information, and the information was promised.
Yeah, but he didn't say I'm not coming to this. He didn't say I'm not coming to this mediation. There's no basis for it in criminal law.
No, and we haven't challenged the legality of it. We simply raised it as a curiosity.
Now, just so you address it fully, the point is we have 2 mediations before the election, and what mediations we know what mediation is supposed to do. And in December, there was another mediation at which agreements were made for Mr. Hilaire to drop his civil litigation against the Comptroller of Customs, and then the prosecution discontinued. The question I ask is, if this was an effort to settle the case that was ongoing all along, how fair would it be to say, well, the dropping of the case was all due to political pressure?
I think, again, let's put it in context. And it also takes me to the point that one of the points my learned friend made earlier. This was a failure to provide information. That's what the case was about. They had attempted, before the prosecution was instituted, they had attempted to get Dr. Hilaire to comply by providing the information that they were requesting. Over a period of a year or so, they were back and forth trying to get this information. The prosecution was instituted, the information's laid, and an attempt to get the same information was being pursued. Promises were made, never kept. according to Chico. And so the information has never to this day been provided, and the basis for the offense still remains.
Is that really fair to say? Let me tell you why I asked that question. We're looking at appeal record. I believe Mr. Estefan was alluding to where it is on the record earlier. But if you looked at appeal record 616, page 616, and also page 715, you see what's happening there. There is an invoice. Those are records, the same document, the invoice of the Land Rover. 616 is easier to read. The 715.
Yeah, I'm familiar with the invoice.
So that is the invoice for the document, for it. So technically what Mr. Chico was saying, provide the invoice. Now, from my reading the record, I didn't see that the request was, Mr. Hilaire, Dr. Hilaire, provide invoice that has your name on it, is provide the commercial invoice. We see the commercial invoice in there. Is
proof of ownership, I believe,
is Mr. Emmanuel wrong to say, hang on, if what we are asking for, the reason for this prosecution is to provide the invoice, we have the invoice there. We have it. It's a different question what interpretation we gave to the invoice. The invoice we have does not have Mr. Hilaire's name on it. But that's a different question about whether or not the commercial invoice for the Land Rover was there. That interpretation and the conclusion for it can lead to some other processes, so to speak. But if the question was, we want to see the invoice that led to the importation of this particular vehicle into the country, Mr. Emmanuel saying, well, we had that all along.
So,
is that a wrong way to look at it? Please tell me.
So I think you go back to where you started earlier, sir, Your Honor, where you said the process initiated with the Director of Finance saying, listen, we have information that assets of the state have somehow found their way in the hands of a private citizen. And the Comptroller of Customs, who is responsible for regulating imports, was enlisted, the assistance of the Comptroller of Customs was enlisted to investigate the matter. And in that context, he said, well, Dr. Hilaire, you are bringing this vehicle in your name. Can you provide proof of ownership? And that was the focus, proof of ownership. Provide the invoice proving that this is yours. And if you look at page 616, which Your Honor pointed me to, you'll see at the top of that invoice, invoice to Saint Lucia High Commission.
Yes.
So the invoice proves ownership of the state, which falls directly in line with what the Director of Finance was saying. Well, on the face of it, this vehicle belongs to the Saint Lucia High Commission. It's a property of the state. Yet we have Dr. Hilaire bringing in the same vehicle in his name as his personal property. And so the question was...
But the explanation, though, from, again, my reading of record here, was that the explanation was, well, Dr. Hilaire wanted to buy a second vehicle at a diplomatic discount or with diplomatic privileges, but couldn't buy that because he already bought one within 9 months. So he uses the name of the High Commission to buy the second one. So there's no question.
He committed a fraud against the revenue in the UK. Is that?
That's a business for the revenue in the UK. That's the case.
That's the implication.
So the point is this: couldn't a second officer say, "Hang on, yeah, I buy the explanation. It shouldn't have happened, but we're gonna let this thing go," with a warning, "Don't do this again." It's a different proposition to say that dropping the case was an abuse of discretion on the part of the person who said, well, I'm going to leave this thing now and concentrate on other things more important for the state?
I think the issue here is an investigative process was commenced. Dr. Hilaire was asked to prove ownership. I mean, the allegation that the property, the vehicle belongs to the state and it's somehow being, let's be fair, purloined by Dr. Hilaire is a serious allegation, yes. And that's why serious and mature investigations were called for and were pursued for 3 years.
But that did not result in any charge against him for misappropriation of government property. It's only about.
Well, because that part of the investigation has never been completed because the roadblock there was a stumbling block in that Dr. Hilaire was not cooperating in providing proof of ownership, which was the focus of the investigation. Prove that you own this vehicle. That's all we're asking, so that you can make a perfect entry. You can't import a vehicle in your name if it doesn't belong to you.
Counsel, in relation to this matter of the magistrate obviously promoting mediation, what engages me is the thought that the offense for which there was this prosecution carried a fine of $5,000, no imprisonment.
Correct. I was going to make that point.
Therefore, counsel, it seems to me that the magistrate would have been purely as a judicial officer, as a legal professional, very, very well grounded in thinking, man, this thing here is really taking up time before me, which is unnecessary. Let's have this thing settled between you all, work it out. Had that taken place, we would not have had 2 legal heavyweights being brought in even now to deal with this matter at the cost of the pockets of the various clients in relation to the issue.
The only fault I have with that statement, Your Honor, is that you characterize me as a legal heavyweight.
Oh, Mr. Patterson,
I totally disagree.
You have appeared before sufficient times for us to know that I do not speak superfluously.
Well, sir, I actually wanted to touch on that point about the fine being, the offense carrying a fine of $5,000 and no imprisonment. So it goes to the argument my learned friend states, relying on Sharma, that the more serious the allegation, the higher the level of scrutiny. And so putting it in context, as you've correctly pointed out, this wasn't a serious case. This wasn't a serious allegation. It was an allegation. You've refused to provide information. Give us the information if you only provide it.
Well done, Mr. Patterson. But it's an offense, and you are recorded as committing such. I think we have to wind up now. Do you have any other point you want to make in response to what Mr. Patterson said?
So that was a response there. My learned friend submitted that Moss, referred the court to paragraph 27 of Moss, and submitted that Moss doesn't apply because, in effect, the Comptroller of Customs is an independent prosecutor. I don't know where the evidence of that is. What provision of the statute is he relying on to establish that the comptroller is anything but a member of the executive branch? Where does this independence derive? We know the DPP's independence is established by the Constitution, the provisions of the Constitution. It's guaranteed by it. We don't see any such provision in the Customs Act. There's no such provision. So where is this notion that the comptroller enjoys independence?
Okay.
Those are all my submissions. Your Honors, thank you for the.
Mr. President, before you adjourn, may I say something?
Of
I
course,
wish to congratulate you on your appointment as president of the CCJ. I think it's well deserved. Even I was going to make a joke, but I shouldn't. But thank you so much. Not thank you so much. My sincerest congratulations, Mr. President. Well deserved.
Thank you very much. And I
I
assure
will
you
take it that
that
you are speaking on behalf of yourself and your learned colleague,
Yes.
so it does not appear that you are
Yes.
seeking to get on the good side of the president.
Well,
I was going to point out that it was a little bit of sucking up, but I was not going to point that out.
No, I'm not accustomed to sucking up, Mr. Patterson, and you know that. Mr. President,
But
congratulations.
I want to join with my learned friend in those
Yes.
sentiments, and the fact that you're Jamaican is not lost on me.
Okay.
And the fact
that's
that
what you
another
call
member of
like-
your bench is.
I think Mr. Asafani might have a one-up on you there, but thank you both very much. And of course, we take it in the spirit in which it was
Your
said.
Honor.
And yes,
Excuse me, I really apologize. This is Alan Chastanet. And I will just ask for permission whether I can just say one thing to was said, because I think it was very, very pertinent. But if I'm not allowed to, I accept that. And I just want to ask for permission if I can.
well, Mr. Chastanet, I think you're very well represented by attorneys here. And you may have heard the presentation by your attorney, extremely capable and well done. But I'm curious, are you there?
I am right here.
Yes. I'm curious to hear what you have to say. It's going to be very brief, I think.
And it's going to be very, very brief. That's actually not. I just want to clarify something, because the statement was made with regards to Dr. Hilaire putting the car in the name of the High Commission, and it was an avoidance.
Sorry, I'm sorry. If you're going into an issue of fact which has been argued before, I'm afraid I don't think
Yes.
we would need to hear that. I thought you were making a different kind of comment.
Fine.
Yeah.
No, that's
Thank
fine.
you, thank you,
Thank
sir.
you.
Appreciate
Thank
it.
you very
As I
much.
said,
I
your
appreciate it.
attorney represented you with distinction as usual. Thank you very much.
Of course he did. Thank you.
Yeah, thank you. Thank you, Council, once again for your presentations and submissions. We'll take some time to consider these submissions, and once we have a decision, we will get back to you. Thank you very much indeed. Madam Deputy Registrar, please.
Thank you, President Anderson. Thank you, Madam Justice Raj-Nutley. Thank you, Mr. Justice Barrow. Thank you, Madam Justice Onanu. And thank you, Mr. Justice Ibu Suji. Thank you, Council. And thank you to the staff of the Caribbean Court of Justice. This court now stands adjourned. Good day to all. Thank you.
Thank you.
Thank you very much.